You're listening to Spiritual North. Thanks for tuning in. Today I'm going to orate the Antarctic Treaty. It's in three parts. The first part is a letter from the President of the United States at the time, Dwight D. Eisenhower. The second part is a letter to Congress urging the acceptance of the treaty to Senate by the Secretary of State. And the third part is the treaty itself. Part 1. Message from the President of the United States. Transmitting. A certified copy of the Antarctic Treaty signed at Washington on December 1st, 1959 by the plenipotentiaries of the United States of America and 11 other countries. February 15th, 1960. Treaty was read the first time and the injunction of secrecy was removed therefrom. The treaty, the President's message of transmittal, and all accompanying papers were referred to the Committee on Foreign Relations and ordered to be printed for the use of the Senate. The White House, February 15th, 1960. Okay, so this is by Dwight. To the Senate of the United States. With a view to receiving the advice and consent of the Senate to ratification, I transmit herewith a certified copy of the Antarctic Treaty, signed at Washington on December 1st, 1959, by plenipotentiaries of the United States of America and 11 other countries. This is a unique and historic treaty. It provides that a large area of the world, an area equal in size to Europe and the United States combined, will be used for peaceful purposes only. It contains a broad, unrestricted inspection system to ensure that the non-militarization provisions will be carried out. The purposes and provisions of the treaty are explained in the report of the Secretary of State, which is transmitted herewith. That's part 2. I transmitted also, for the information of the Senate, a certified copy of the final act of the Conference on Antarctica held at Washington October 15th to December 1st, 1959, at which the treaty was formulated. The final act does not require ratification. I'm gratified to recall that it was at the initiative of the United States that the Conference on Antarctica was convened. On May 2nd, 1958, the United States extended to the 11 other countries which participated in the Antarctic program of the International Geophysical Year an invitation to participate in a conference to consider the conclusion of a treaty on Antarctica for certain stated purposes. The invitation was accepted by all 11 countries: Argentina, Australia, Belgium, Chile, the French Republic, Japan, New Zealand, Norway, the Union of South Africa, the Union of Soviet Socialist Republics, and the United Kingdom of Great Britain and Northern Ireland. The spirit of cooperation and mutual understanding with which representatives of the 12 countries drafted the Antarctic Treaty and signed it for their respective governments is an inspiring example of what can be accomplished by international cooperation in the field of science and in the pursuit of peace. I believe that the Antarctic Treaty is a significant advance toward the goal of a peaceful world with justice, in the hope that the United States, which initiated the idea of the Antarctic Treaty, may be one of the first to ratify it. I recommend that the Senate give it early and favorable consideration. Dwight D. Eisenhower. The White House, February 15th, 1960. Enclosures: 1. Report of the Secretary of State. 2. The Antarctic Treaty, certified copy. 3. U.S. Government note of May 2nd, 1958. 4. Final act of the Conference on Antarctica, certified copy. Department of State, Washington, February 4th, 1960. Part 2. The President. The White House. I have the honor to submit to you, with a view to its transmission to the Senate for advice and consent to ratification, a certified copy of the Antarctic Treaty signed at Washington on December 1st, 1959, on behalf of the United States of America and 11 other countries. Those countries are Argentina, Australia, Belgium, Chile, the French Republic, Japan, New Zealand, Norway, the Union of South Africa, the Union of Soviet Socialist Republics, and the United Kingdom of Great Britain and Northern Ireland. The treaty was formulated at the Conference on Antarctica, held at Washington from October 15th to December 1st, 1959. The idea for the conference was initiated by the government of the United States, which, on May 2nd, 1958, extended an invitation to take part in such a conference to the 11 other countries which participated in the Antarctic program of the International Geophysical Year. A copy of the U.S. Note of Invitation, dated May 2, 1958, is enclosed for transmittal to the Senate for its information. Acceptances were received from all 11 governments, and subsequently, informal preparatory talks were held in Washington among representatives of the 12 countries. When the conference convened on October 15, 1959, it used as a basis for discussion working papers considered in the course of the preparatory talks. The treaty, formulated at the conference and signed on behalf of all 12 countries, incorporates the basic purposes of the U.S. proposal and provides practical means for their fulfillment. The treaty consists of a preamble and 14 articles. It was drafted as stated in the preamble in recognition that it is in the interest of all mankind that Antarctica shall continue forever to be used exclusively for peaceful purposes and shall not become the scene or object of international discord. The preamble also makes clear that the treaty is designed to further the purposes and principles embodied in the Charter of the United Nations. Article 1 dedicates Antarctica to peaceful purposes only. It outlaws measures of a military nature, such as the establishment of military bases and fortifications, the carrying out of maneuvers, and the testing of weapons. It specifies that military personnel or equipment may be used there for scientific research or any other peaceful purpose. As the United States and a few other countries have conducted their Antarctic programs with logistic support provided by their military establishments, the latter provision was considered appropriate to dispel any doubt that peaceful programs could continue to be carried out in this way. Article 2 provides that freedom of scientific investigation in Antarctica and cooperation toward that end, as applied during the International Geophysical Year, shall continue subject to the provisions of the treaty. Article 3 contains provisions for the promotion of such international scientific cooperation. Under its terms, the parties agree that scientists may be exchanged between expeditions and stations in Antarctica. The parties also shall keep one another informed of their plans for scientific programs in Antarctica and shall make freely available scientific observations. Such exchanges would be made to the extent that the parties consider it feasible and practicable. The article also encourages the establishment of cooperative working relations with those specialized agencies of the United Nations and other international organizations having a scientific or technical interest in Antarctica. Article 4 specifies that nothing in the treaty will be interpreted as a renunciation of any party's claim to sovereignty, as a renunciation or diminution of any party's basis of claim, or as prejudicing the position of any party regarding recognition or non-recognition of another party's claim or basis of claim. The article also specifies that while the treaty is in force, no acts or activities will constitute a basis for asserting, supporting, or denying a claim or create any rights of sovereignty in Antarctica. It is finally provided that no new claims can be made and no existing claims enlarged while the treaty is in force. It is believed that the manner in which the treaty deals with the sensitive problem of territorial claims is one of its most significant aspects. 7 of the 12 countries which signed the treaty have for many years asserted claims of sovereignty to portions of Antarctica, some of which overlap and have given rise to occasional frictions. The claimants are Argentina, Australia, Chile, France, New Zealand, Norway, and the United Kingdom. Neither the United States nor the Soviet Union has made any territorial claims, nor do they recognize the claims of others. Other non-claimant countries which are signatories to the treaty are Belgium, Japan, and the Union of South Africa. In essence, Article 4 minimizes the possibility that disputes over claims to sovereignty will erupt and interfere with constructive scientific work in Antarctica. In Article 5 bans all nuclear explosions in Antarctica and the dumping there of radioactive waste material pending the conclusion of international agreements on nuclear uses. In effect, this provision prevents Antarctica from being used as a nuclear proving ground or as a dumping ground for radioactive waste. It prevents the possibility that harmful fallout will be carried to neighboring regions. However, this article does not prevent the use of nuclear energy in atomic power plants. Article 6 establishes the zone of application of the treaty. By its terms, the treaty applies to the area south of 60 degrees south latitude, including ice shelves, that is, thick portions of ice attached to the land and extending seaward, but the rights of any state under the international law with regard to the high seas within the area are not affected. Article 7 contains provisions designed to ensure that the peaceful intent of the treaty is being carried out. It permits the signatory parties and any acceding parties qualified to participate in the consultative meetings to send observers anywhere in Antarctica at any time. The observers must be nationals of the sending party, and their designation must be made known to every other party having the right to send observers. They are to have complete freedom of access to all areas of Antarctica and must be permitted to inspect stations, installations, and equipment, as well as ships and aircraft at points of discharging or embarking cargoes or personnel in aerial observation by any country having the right to send observers is also permitted. Parties are required to furnish advance notice of all Antarctic expeditions by their ships or nationals, and all Antarctic expeditions organized in or proceeding from their territories. They must also report all stations in Antarctica occupied by their nationals, and all military personnel or equipment intended to be sent to Antarctica for peaceful purposes. The requirement to give advance information would not, of course, prevent previously notified plans from being modified or revised upon further notice, whenever advisable, because of unforeseen events such as budgetary limitations, weather, or damages to ships or equipment. Under Article 8, each party has exclusive jurisdiction over its own nationals who are observers designated under the treaty for inspection purposes or scientific personnel exchanged between expeditions or stations in Antarctica in respect of all acts or omissions occurring while such persons are in Antarctica for the purpose of exercising their functions. Members of the staffs accompanying such persons are also covered. The positions of the parties relating to jurisdiction over all other persons in Antarctica are not affected. The parties agree to consult together immediately should any dispute arise concerning the exercise of jurisdiction in Antarctica. Under Article 9, representatives of the 12 signatory states are to meet in Canberra, Australia, within 2 months after the treaty enters into force, and thereafter at times and places which they deem suitable. Their functions will be to exchange information, to consult together on matters of common interest pertaining to Antarctica, and to recommend to their governments measures in furtherance of the principles and objectives of the treaty. These measures are to become effective when approved by all of the parties who were entitled to participate in the meetings held to consider those measures. A country which has become party to the treaty by accession may qualify to participate in the meetings during such time as it demonstrates its interest in Antarctica by conducting substantial scientific research there. Representatives participating in the meetings will receive the reports of observers carrying out inspection under the treaty. Regardless of whether measures to facilitate the exercise of treaty rights are adopted, all rights established by the treaty, including, of course, rights to conduct inspection, may be exercised from the date the treaty enters into force. By Article 10, the parties are obliged to exert appropriate efforts, consistent with the Charter of the United Nations, to see that no one engages in activity in Antarctica contrary to the principles of the treaty. Its aim is not only to prevent such activity by nationals and organizations under the jurisdiction of the parties, but to deter countries which are not parties to the treaty and their nationals and organizations from engaging in non-peaceful activities in Antarctica. In effect, it pledges the parties not only to refrain from giving assistance to persons or countries which might engage in non-peaceful activities or atomic tests in Antarctica, but to take active steps to discourage any such activity. Under Article 11, disputes among the parties arising under the treaty are to be resolved by peaceful means of their own choice, such as arbitration, conciliation, or the like. If this proves unsuccessful, the dispute is to be referred to the International Court of Justice with the consent of all parties to the dispute. Article 12 provides a method for modifying or amending the treaty at any time by unanimous consent of the parties entitled to participate in the consultative meetings. An amendment will enter into force when all such parties give notice that they have ratified it. Parties not entitled to participate in the meetings may accept the amendment within 2 years. If they fail to do so within that time, they will be deemed to have withdrawn from the treaty. The treaty has no specified duration, but Article 12 provides that after 30 years, any of the parties participating in consultative meetings may ask for a conference to review the operation of the treaty. Amendments approved at such a conference by a majority of those represented, including a majority of the consultative parties, will enter into force when ratified by all of the consultative parties. If a modification or amendment approved at such a conference does not enter into force within 2 years, any country may withdraw from the treaty, effective 2 years from its notification to that effect. Article 13 provides that the treaty will enter into force when ratified by all 12 signatory states. It contains an accession clause by which countries other than the original 12 may acquire the rights and assume the obligations embodied in the treaty. All states members of the United Nations and any other state which is unanimously invited by the consultative parties may accede. Article 13 also names the United States as depository government and contains other provisions of a formal nature relating to ratification, accession, and registration with the United Nations. By Article 14, the English, French, Russian, and Spanish language versions of the treaty are declared to be equally authentic. On occasion of the signing of the Antarctic Treaty, the governments of the United States, Argentina, and Chile declared that the treaty does not affect their obligations under the Inter-American Treaty of Reciprocal Assistance, signed at Rio de Janeiro on September 2, 1947. 62nd Statute, 1681. Or 1681. The U.S. representative to the Conference on Antarctica was Ambassador Herman Pfleger, P-H-L-E-G-E-R, former legal advisor of the Department of State. Alternative representatives were Ambassador Paul C. Daniels and Mr. George H. Owen. The U.S. delegation included, in addition to officers of the Department of State, a representative of the Department of Defense. Congressional advisors were the Honorable Frank Carlson and the Honorable Gail W. McGee, U.S. Senators. The delegation received advice directly from the National Science Foundation, the agency responsible for coordinating the planning and management of the U.S. scientific program in Antarctica. It was also advised by a committee of 6 distinguished scientists appointed by the National Academy of Sciences because of their active interest in scientific investigations in Antarctica. There is transmitted for your information and for that of the Senate the final act of the Conference on Antarctica, signed at Washington on December 1, 1959, by the plenipotentiaries of the 12 participating nations. The final act does not require ratification. I believe that the signing of the Antarctic Treaty is a substantial achievement. Its ratification by all the signatory states would further, in an entire continent, peaceful cooperation in the attainment of scientific progress. It is based on the will to maintain peace in an important area of the world. The United States, which has engaged in extensive exploratory and scientific activities in Antarctica, initiated the idea of the Antarctic Treaty, which is believed to be in the best interests of this country and of all mankind. It is hoped, therefore, that the United States may be among the first to ratify it. Respectfully submitted, Christian A. Herter. Enclosures: 1. The Antarctic Treaty, certified copy. 2. U.S. Government Note of May 2nd, 1958, copy. 3. Final Act of the Conference on Antarctica, certified copy. Okay, Part 3, the Antarctic Treaty. I will also timestamp this and leave a link in the description in case you want to skip ahead. The governments of Argentina, Australia, Belgium, Chile, the French Republic, Japan, New Zealand, Norway, the Union of South Africa, the Union of Soviet Socialist Republics, the United Kingdom of Great Britain and Northern Ireland, and the United States of America. Recognizing that it is in the interest of all mankind that Antarctica shall continue forever to be used exclusively for peaceful purposes and shall not become the scene or object of international discord. Acknowledging the substantial contributions to scientific knowledge resulting from international cooperation in scientific investigation in Antarctica. Convinced that the establishment of a firm foundation for the continuation and development of such cooperation on the basis of freedom of scientific investigation in Antarctica, as applied during the International Geophysical Year, accords with the interests of science and the progress of all mankind. Convinced also that a treaty ensuring the use of Antarctica for peaceful purposes only and the continuance of international harmony in Antarctica will further the purposes and principles embodied in the Charter of the United Nations, have agreed as follows. Article 1. Antarctica shall be used for peaceful purposes only. There shall be prohibited, inter alia, any measures of a military nature, such as the establishment of military bases and fortifications, the carrying out of military maneuvers, as well as the testing of any type of weapons. 2. The present article shall not prevent the use of military personnel or equipment for scientific research or for any other peaceful purpose. Article 2. Freedom of scientific investigation in Antarctica and cooperation toward that end, as applied during the International Geophysical Year, shall continue subject to the provisions of the present treaty. Article 3. In order to promote international cooperation in scientific investigation in Antarctica, as provided for in Article 2 of the present treaty, the contracting parties agree that, to the greatest extent feasible and practicable, a. Information regarding plans for scientific programs in Antarctica shall be exchanged to permit maximum economy and efficiency of operations. B. Scientific personnel shall be exchanged in Antarctica between expeditions and stations. C. Scientific observations and results from Antarctica shall be exchanged and made freely available. Part 2. In implementing this article, every encouragement shall be given to the establishment of cooperative working relations with those specialized agencies of the United Nations and other international organizations having a scientific or technical interest in Antarctica. Article 4, Part 1. Nothing contained in the present treaty shall be interpreted as a renunciation by any contracting party of previously asserted rights of or claims to territorial sovereignty in Antarctica. B. A renunciation or diminution by any contracting party of any basis of claim to territorial sovereignty in Antarctica, which it may have whether as a result of its activities or those of its nationals in Antarctica or otherwise. C. Prejudicing the position of any contracting party as regards its recognition or non-recognition of any other state's right or claim or basis of claim to territorial sovereignty in Antarctica. 2. No acts or activities taking place while the present treaty is in force shall constitute a basis for asserting, supporting, or denying a claim to territorial sovereignty in Antarctica or create any rights of sovereignty in Antarctica. No new claim or enlargement of an existing claim to territorial sovereignty in Antarctica shall be asserted while the present treaty is in force. Article 5, Part 1. Any nuclear explosions in Antarctica and the disposal thereof radioactive waste material shall be prohibited. Part 2. In the event of the conclusion of international agreements concerning the use of nuclear energy, including nuclear explosions and the disposal of radioactive waste material, to which all the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9 are parties, the rules established under such agreements shall apply in Antarctica. Article 6. The provisions of the present treaty shall apply to the area south of 60 degrees south latitude, including all ice shelves. But nothing in the present treaty shall prejudice or in any way affect the rights or the exercise of the rights of any state under international law with regard to the high seas within that area. Article 7. In order to promote the objectives and ensure the observance of the provisions of the present treaty, each contracting party whose representatives are entitled to participate in the meetings referred to in Article 9 of the treaty shall have the right to designate observers to carry out any inspection provided for by the present article. Observers shall be nationals of the contracting parties which designate them. The names of observers shall be communicated to every other contracting party having the right to designate observers, and like notice shall be given of the termination of their appointment. Each observer designated in accordance with the provisions of paragraph 1 of this article shall have complete freedom of access at any time to any or all areas of Antarctica. 3. All areas of Antarctica, including all stations, installations, and equipment within those areas, and all ships and aircrafts at points of discharging or embarking cargoes or personnel in Antarctica, shall be open at all times to inspection by any observers designated in accordance with paragraph 1 of this article. 4. Aerial observation may be carried out at any time over any or all areas of Antarctica by any of the contracting parties having the right to designate observers. Each contracting party shall, at the time when the present treaty enters into force for it, inform the other contracting parties, and therefore shall give them notice in advance of a. all expeditions to and within Antarctica on the part of its ships or nationals, and all expeditions to Antarctica organized in or proceeding from its territory. B. All stations in Antarctica occupied by its nationals, and C. Any military personnel or equipment intended to be introduced by it into Antarctica subject to the conditions prescribed in paragraph 2 of Article 1 of the present treaty. Article 8. 1. In order to facilitate the exercise of their functions under the present treaty, and without prejudice to the respective positions of the contracting parties relating to jurisdiction over all other persons in Antarctica, observers designated under paragraph 1 of Article 7 and scientific personnel exchanged under subparagraph 1b of Article 3 of the treaty and members of the staffs accompanying any such persons shall be subject only to the jurisdiction of the contracting party of which they are nationals in respect of all acts or omissions occurring while they are in Antarctica for the purpose of exercising their functions. Without prejudice to the provisions of paragraph 1 of this article, and pending the adoption of measures in pursuance of subparagraph 1e of Article 9, the contracting parties concerned in any case of dispute with regard to the exercise of jurisdiction in Antarctica shall immediately consult together with a view to reaching a mutually acceptable solution. Article 9. 1. Representatives of the contracting parties, named in the preamble to the present treaty, shall meet at the city of Canberra within 2 months after the date of entry into force of the treaty, and thereafter at suitable intervals and places, for the purpose of exchanging information, consulting together on matters of common interest pertaining to Antarctica, and formulating and considering and recommending to their governments measurements in furtherance of the principles and objectives of the treaty, including measures regarding A. Use of Antarctica for peaceful purposes only. B. Facilitation of scientific research in Antarctica. C. Facilitation of international scientific cooperation in Antarctica. D. Facilitation of the exercise of the rights of inspection provided for in Article 7 of the treaty. E. Questions relating to the exercise of jurisdiction in Antarctica. F. Preservation and conservation of living resources in Antarctica. Part 2. Each contracting party which has become a party to the present treaty by accession under Article 13 shall be entitled to appoint representatives to participate in the meetings referred to in paragraph 1 of the present article during such time as that contracting party demonstrates its interest in Antarctica by conducting substantial scientific research activity there, such as the establishment of a scientific station or the dispatch of a scientific expedition. 3. Reports from the observers referred to in Article 7 of the present treaty shall be transmitted to the representatives of the contracting parties participating in the meetings referred to in paragraph 1 of the present article. 4. The measures referred to in paragraph 1 of this article shall become effective when approved by all the contracting parties whose representatives were entitled to participate in the meetings held to consider those measures. 5. Any or all of the rights established in the present treaty may be exercised as from the date of entry into force of the treaty, whether or not any measures facilitating the exercise of such rights have been proposed, considered, or approved as provided in this article. Article 10. Each of the contracting parties undertakes to exert appropriate efforts consistent with the Charter of the United Nations, to the end that no one engages in any activity in Antarctica contrary to the principles or purposes of the present treaty. Article 10. Article 11. If any dispute arises between two or more of the contracting parties concerning the interpretation or application of the present treaty, those contracting parties shall consult among themselves with a view to having the dispute resolved by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, or other peaceful means of their own choice. 2. Any dispute of this character, not so resolved shall, with the consent in each case of all parties to the dispute, be referred to the International Court of Justice for settlement, but failure to reach agreement on reference to the International Court shall not absolve parties to the dispute from the responsibility of continuing to seek to resolve it by any of the various peaceful means referred to in paragraph 1 of this article. Article 12. 1a. The present treaty may be modified or amended at any time by unanimous agreement of the contracting parties, whose representatives are entitled to participate in the meetings provided for under Article 9. Any such modification or amendment shall enter into force when the depository government has received notice from all such contracting parties that they have ratified it. B. Such modification or amendment shall thereafter enter into force as to any other contracting party when notice of ratification by it has been received by the depository government. Any such contracting party from which no notice of ratification is received within a period of 2 years from the date of entry into force of the modification or amendment in accordance with the provisions of subparagraph 1A of this article shall be deemed to have withdrawn from the present treaty on the date of the expiration of such period. 2A. If after the expiration of 30 years from the date of entry into force of the present treaty, any of the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9 so requests by communication addressed to the depository government, a conference of all the contracting parties shall be held as soon as